All right, we're going to talk about some legal and ethical guidelines that lead our practice when it comes to mental health nursing. Here are three basic ethical concepts: ethics, bioethics, and ethical dilemmas. These are acts that reflect a commitment to standards beyond someone's personal preferences. So this is standards that individuals, professions, and societies strive to meet. Using this standard process to think through ethical dilemmas is going to help nurses deal with different ethical issues. There is a code of ethics, and what it is used as a foundation for professional nurses to follow. There's 5 principles of bioethics, and they're listed here with their definitions. The respect for autonomy is going to refer to a commitment to include patients in all decision making about their care in a way of also providing with acknowledging their preferences and protecting them and giving them as much independence as they can have. With beneficence, this is usually very fundamental when you're practicing nursing and in medicine, and it's the duty to do no harm, to promote a good. Maleficence refers to do no harm or hurt, so non-maleficence is to avoid any type of harm or hurt. So in healthcare, ethical practice is going to involve not only doing the will to do good, but also a commitment to do no harm. And then you have justice, and this refers to a fairness. This is usually in discussions, brought up in discussions when it comes to access of healthcare and healthcare resources and how it's distributed. When you think about civil rights, as we learned also with our guest speaker, that everyone has rights, whether they have a mental illness or not. So please look at your bullets on page 99 through 100. One thing we have are known as drug courts, and this is more of an emphasis on rehabilitation and rehabilitating the patient rather than punishing them. Then there's going to be some laws. Some may be criminal, some may be civil, and this is underneath statutory law. And when you have statutory laws, your criminal laws and civil laws, like I said, fall under them. Your criminal law is meant to prevent harm to society and to provide some type of punishment for crimes. Your felonies and misdemeanors. Your felonies are those more serious crimes. They're going to be in prison for longer than a year, and usually can even involve a death penalty. Your misdemeanor is going to be your lesser crimes. They're not as serious, and so the penalty may be a fine or some type of imprisonment that's less than a year. Your civil laws usually protect the rights of individuals, and this is usually damages. So there's usually some type of payment or a fine that is awarded to individuals who win those cases. You also have regulatory laws, which are also known as your administrative laws, and this is going to define your duty to report something that's incompetent or some type of unethical nursing conduct to the Board of Nursing. Remind me, and I will in class talk to you about a Dateline that was on the other night that was really interesting that is related to this. Another is common law results, and this is judicial decisions that concern individual cases. So most of these are going to revolve around negligence, or someone suing a facility, a doctor or a nurse, for malpractice. One thing I do want to touch on is that there are rules and regulations that are going to be set by state governments. So it's really important that you know the laws of the states in which you're going to practice in, because they can vary considerably when it comes to, as I said, the different statutes and the regulations. When we talk about the due process in involuntary commitment, writ of habeas corpus This is used to challenge unlawful detention by the government. It's a formal written order to free the patient. And this is used to challenge commitments. You want to use the least restrictive alternative doctrine, and this is usually applied to civil commitment cases. And so they're going to use the least drastic means in those situations. When it comes to admission procedures, you have informal, voluntary, and temporary. Your informal is usually requested by or sought by the patient. There are no formal or written applications. The patient's free to stay and leave. And again, they have that normal doctor-patient relationship. When it comes to a voluntary admission, either the patient or a guardian may seek this, and it applies to writing for admission to a facility. If they're under 18, a parent can give authority. They do have the right to request or obtain some type of release. They are reevaluated and can be. This can be also changed to an involuntary admission once they are reevaluated. Temporary admission. This is when the person is confused or demented and they're so ill that he or she needs emergency admission. Let's say someone starts walking, buck naked down the grocery store and starts singing, tra la 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 la, and so someone knows something's wrong, and so they're going to do a temporary admission and evaluate that patient. Involuntary admission, this is without the patient's consent. At least 2 physicians usually certify that their mental health is going to justify some type of detention and treatment. So again, involuntary is without the patient's consent. Long-term involuntary admission, usually it's an extended hospitalization through some type of medical certification. It goes under judicial review and administrative actions. Usually it's 60 to 180 days. And then you have your involuntary outpatient admission. And this is an alternative to some type of forced involuntary patient treatment. This can be a preventative measure, allowing the court order before a crisis that would actually result in something that could be even worse. So someone who is usually at risk for harming themselves or someone else. Discharge procedures, your conditional release, they must adhere to outpatient treatment during a specific time period, adhere to taking their medications, and have the ability to meet their own basic needs and be able to reintegrate into the community. If it's an unconditional release, termination of the relationship between the patient and the institution. They have ended it. AMA is a disagreement between the provider and the patient to continue with the hospitalization. So treatment may be beneficial, but there's no compelling reason to continue, and so they decide to end that relationship, so to speak. Here's a list of patient rights under the law. I'll let you read through these. These patients have the same patient confidentiality and legal considerations just like anyone else. They do have the HIPAA that provides them their rights to privacy and protects them, it protects them from losing their health insurance when changing jobs. They also have privacy against rules against patients' rights of information to be disclosed, and they can look at their own medical records. They have, as I said, the rights of privacy and confidentiality, and it's just like anyone else. The exception to the rules will be if they are at risk to harm someone else, and we need to warn those people or protect third parties. Also, any type of situations where there's child and elder abuse, there are reporting statutes that would override this confidentiality. In case you don't remember from last semester, here's a review about tort law. Again, a tort is a civil wrong made against a person or a property. And then you have your intentional torts. This is your assault and battery. It violates the rights of someone else. It includes also false imprisonment. An assault can be actual or may be a threat given towards someone, such as giving a person an injection or threatening to restrain a patient who has refused procedure. And of course, battery is intentional touching without their consent. False imprisonment is a tort, and so this would be restraining a patient without any type of justification. A couple of others would also be invasion of privacy, going through someone's things. However, when patients are admitted into an inpatient facility, we do need to go through anything that could be harmful to themselves or others. And then defamation of character, which is libel and slander. And if you'll recall, unintentional torts or consist of negligence and malpractice. So negligence is conduct that falls below the standards of care, where your malpractice is one type of negligence that is often referred to as professional negligence. So when nursing care falls below the standard of care, nursing malpractice can result. There's 5 elements to prove for negligence, and this is these are listed here. An institution has a duty to maintain nursing records. Statutes and accreditation regulations establish these duties. Nursing notes contain substantial evidence that's needed to understand the care received by a patient. And so these records, if they're lost or incomplete, it can be presumed that the care that someone was given was negligent and therefore was the cause of a patient's injuries. Someone will actually go through these. It's usually a paralegal nurse, and they will go through all notes, documents with a fine-tooth comb. They find anything that's not documented, and the doctor says they did it, or the nurse said they did do it, but it's not documented. It's not done, and that case can go against that physician, that facility, or that nurse. The best way for nurses to avoid malpractice is to follow the standards of care, give competent health care, and communicate with all other healthcare providers. So it's vitally important that you communicate with the patient, explain tests and treatments, document that you provided specific explanations to either him or her, and listen to their concerns about their treatments. So some guidelines to ensure adherence for the standards of care. This is the standards for psychiatric mental health nursing practice. This is established by the ANA, and the ANA also posts to our Code of Ethics. Negligence is irresponsibility or impairment in duty to intervene or in duty to report. So we need to report suspicions or intervene anytime we see negligence. In most states, it is legally your duty. You need to document any evidence, report impaired colleagues. You may not be witness to direct care, but it could be a concern, and so you need to bring that to the board's attention. How accurately and completely a documentation is vital, because it portrays the patient's behavioral status at the time it was written, and this is important when you're going to be reading it and looking at it at a later date. So it's very, very important that you document, and so when you read it 3 years down the road, will you know exactly what you did or did not do? You need to report and document the facts, not your feelings, but what happened, what you observed, what you saw, what was done. So here's a little YouTube video you can watch about documentation. When it comes to medical records, this is going to give the information to the facility about the quality of care that was given and how improvements can be made. They can also, it allows them to look for continuity of care, and it is a legal document.